Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How's it going, guys? Woo! Sorry for that. I always try to predict how long it's going to take me between shows, and I'm always wrong. But c'est la vie. C'est la vie. How we doing, guys? It is a Monday, and this has been a actual very great Monday for me. And it has made me forget for a minute that it is December, which is nice. I'm in a fantastic fucking mood. Let's see if we can ruin it with some news stories from around the world. Actually, not really from around the world so much as right here in the good old U.S. of fucking A. And not in the good way. But we do have a couple today. We've got Trump, because his New York appeals case is coming to a finality, as we briefly discussed, I think, on Friday or something like that. It is coming to completion. His, hold on, I'm getting situated here. His attorneys have made a final motion to dismiss the lawsuit brought by New York Attorney General Letitia James under a very suspect New York statute. And I mean a very suspect New York statute that removes any possibility of a, of a criminal, well, it's not a criminal trial, they say, and removes any possibility of having a jury. You're not entitled to one under the New York or federal constitutions for a civil case. And so you don't have it. Now, despite that, in a civil case, you have a redress of grievances, which involves money as compensation for a wrong, some sort of tort or other wrong has happened to you. The court has the ability to make it right, either by exchanging property, services, or money being a representation of all these things, ultimately back to the aggrieved party from the aggrieving party, right? Very much makes sense. Civil trials don't necessarily confer a right to a jury, because there are some situations we could see maybe where a jury isn't appropriate for this. But at the end of the day, civil trials have a victim who is being recompensed by the government for an aggrieving party. Now, criminal trials are a little different. Criminal trials are crimes against the state. Now, they involve real victims, and the state may in some way pass along some sort of restitution, is what they call it, to a victim. But the state is ultimately saying that what you do is an infraction against the state, or really the people of the state. You may have a specific crime of murder, but the state doesn't want murderers. So the state is going to actually take over that case, and they're going to prosecute it in a criminal manner, with the stated goal of protecting its citizenry, which means the state is going to leverage the full force of the state's resources against the defendant, right? Like, that's the idea. Now, supposed to be as ballast for this, we have these robust constitutional protections in the 4th, 5th, and 6th Amendment to try and keep the government from cheating against a personalized vendetta, to ultimately respect the rights of the accused all the way through their deprivation of liberty. But the entire concept is you are taking away from the state, so the punishment goes to the state. The punishment is either criminal commitment in an institution that says you cannot be out into the wild. You have to do this thing with the government, which is kind of why people who say that, like, doing various government tasks while working at a prison is, some people complain that it's slavery or something like that. It's nothing of the sort. It is an involuntary servitude, except for the fact that you volunteer by committing a felony or whatever. We're not going to get too deep into that argument, but the reality is you're paying back the state. And one way you're paying back the state is by not being on the street to put other people at risk of your risky behavior. which is why typically we're looking to lock up violent offenders, people who commit offenses against property, who are likely to reoffend. And there are other types of offenders who aren't super likely to reoffend or who aren't necessarily a danger to the community, even though they've done some sort of criminal infraction. And we shouldn't be as interested in locking those people up. Really, we're looking at you, states that have felony punishments for marijuana users. Mostly, you're talking about relatively victimless crimes. And for everybody who says, well, a marijuana user might get in a car and murder someone, we have crimes that cover that. And those are different. Those crimes can be punished as they come up. But we're getting away from those questions right now. And we're just going to focus on the fact that criminal charges tend to have repayment to the state, either in the terms of fines that are paid to the state or in terms of criminal commitment to remove you from society for a period of rehabilitation and possibly restitution or whatever it is. That's what happens. This is a weird law in New York, which creates a civil offense for alleged victims, but the compensation for the alleged offenses is paid to the government, and the defense is run by the government, and the victim's participation is irrelevant. In fact, the victim's own victimhood is irrelevant to this question. And the fines imposed, like I said, do go back to the government. And there are other potential criminal style takings, the takings of property rights in corporate interests or in corporations, in corporate licensure, and various other professional recognitions. You do have property interests in those things. They're real. Those are things that when the government takes them, that is taking something of value from you. Now, it may be a privilege, but it's a privilege you hold an interest in, if not a right to. And some privileges, you don't have a right to do it until you have the privilege. Then the government taking that privilege away needs to follow some sort of process. Now, in this case, they're saying that this process, which is a bench trial, no chance of a jury trial, no public review, with the full force of the government fighting against you, no alleged victim required, and all of the money that you pay as penalty will be sent back to the government. They're calling that a non-criminal trial. But does that sound non-criminal to you? It doesn't to me. It doesn't sound non-criminal to me. In fact, it sounds specifically criminal. It sounds like I fucking hate it. And it sounds like a violation of the Sixth Amendment, because you should have a right to a jury trial in this. Now, with all of that said, Donald Trump is in this mess. You may love or hate Donald Trump. It does not matter here. He represents the possibility of infractions like this being used against you. He has the fortune of being a billionaire. Do you have the money it takes to fight this? Knowing that, for instance, two of Donald Trump's expert witnesses each charged $900,000 for their expert witness preparation and testimony in this case. Do you have $1.8 million to spend on two witnesses? If you don't, you should be very, very concerned about how this is playing out, because you do not have the same Fourth, Fifth, and Sixth Amendment rights when the government brings a civil case against you. That is not civil in any book that I can see. That is the flex of governmental authority on the citizenry. That should always be criminal, in my opinion. But hey, it's not. Now, this judge is demonstrating how devastating this actually is. And we're going to look at it today. Donald Trump has filed his motion to dismiss this case. It should be dismissed. It should have always been dismissed. The alleged fraud has no victims. The fraud is that he misrepresented on a financial statement. If you know anything about financial statements and how they go, they are opinions, because there is no objective measurement of worth unless you work at McDonald's and don't own anything else. You literally just have a bank account and the clothes on your back. Sure, maybe you can objectively assess someone's true worth. But if you own several properties that are not for sale and have not recently sold, if you have investments, if you have business interests, if you have equity positions, none of those things have fixed values beyond a moment in time. And those moments in time are not always conjoined to happen at the same instant. Otherwise, they're just opinions, and people's opinions differ. Now, if you say someone overinflates their value, it may be true. The next question is, does that overinflation of value affect the underlying terms of whatever they're trying to get? If it does, maybe you move to step 2. If it doesn't, it's dead at step 1. In this case, there are plenty of instances where Trump's case should be dead in the water, but this judge already ruled a fraud before any of that was even be able to be heard at trial. During the trial, they have thrown out and ignored. This judge is going to tell us exactly how he ignores evidence in a way that would be absolutely baffling, but a little more acceptable if it was a juror. But this isn't a juror. This is a judge. This is a judge who's been accused of political bias from the start, and his words ring true of it. So we're going to be talking about that. I know I've just previewed it for a little while, but we're going to be talking deep into that. And then we're going to go into Matthew Perry. Matthew Perry, the hot tub bandit. Oh, no. Matthew Perry tried to take he took a hot tub time machine straight to hell. He is dead, right? He's dead. We all know that he died. We know he died in a hot tub. His autopsy report has come out, and in specific, a toxicology report, and it has been reported. It's reported out there. I hope you guys have seen this, that ketamine was the cause of death by Matthew Perry. Interestingly, I'm pretty sure the person who said that line is not actually the coroner who examined Matthew Perry. This is a sneaky little media tactic that occurred, but the coroner who commented on the acute ketamine overdose happens to be part of an organization. What organization is that? Oh, that's right. Johns Hopkins. What happened recently with Johns Hopkins and ketamine? I don't know. I don't know about that at all. Oh, that's right. They have a $261 million judgment against them related to their refusal to recognize ketamine therapy in a minor, which was just found to be medical malpractice. And that also was found to be the proximate cause of the suicide of the little girl's mother. Now, Johns Hopkins coroner runs a line to the Associated Press about Matthew Perry suffering from acute ketamine overdose with, get this, a contributing factor of drowning. Oh, so the ketamine acute overdose killed him. Why are you qualifying it with an acute overdose? That means that a symptom of the overdose, a symptom of the ketamine, really, not necessarily an overdose in any capacity, but a symptom of the ketamine was a factor in the death of Matthew Perry. Now, the contributing factor of fucking drowning is kind of important. Because ketamine is a paralytic. It's an anesthetic paralytic. And if you take an anesthetic paralytic in a body of water, you die because you sink to the bottom and your face goes under and you can't do anything about it. And with ketamine, you may not even care. It's also a widely recognized dissociative drug, which is why it's a very popular field medic drug for the military. It is used in dental offices for sedation dentistry. It is used in, it's used in all sorts of operating rooms and treatment centers, because what it does is it takes the person's mind away from what's happening in reality while being a paralytic and an anesthetic. It helps to separate them from the possibility of pain, even when other anesthesias may not sufficiently cover the pain itself. It's very hard to overdose on in general, and its usage in situations, and combined with other chemicals that they're kind of leaving out, we're going to talk about those too, can definitely lead to death. You would not want to use ketamine while driving or flying or skydiving or swimming or rock climbing. Terrible plans, all of these things. Don't do that. You'll just fall or slide underwater or crash or die. But you won't die from the ketamine issue. You'll die from the fact that you can't move or think or perceive reality or anything like that. It's amazing. But now, prepare for the blitz. You have a beloved actor. And you have a massively popular medical institution coming together. Well, the beloved actor's dead, so it's not really his choice. Coming together, and you have the perfect recipe for a media blitz on ketamine, and it's already started Megan Fox has already penned an article about this. As you know, she followed the Maya Kowalski trial that I was referencing, in which Johns Hopkins was found to have all this happen. And isn't it fucking convenient that they have the ear of the AP and the Johns Hopkins court did not do the autopsy or the toxicology report independently, reviews the facts, and concludes that Matthew Perry died from an acute overdose, and it gets reported, and now it's being repeated. Well, how does the system work? Just like that. Egalitarian Local says, I didn't see anything other than the ketamine, though. Let me tell you what he was on. I actually have the list. We're going to get into this more, but I want to get into this right away because this is the fact that you didn't see anything other than the ketamine is so fucking dishonest and disingenuous that it's a big part of the story. So we're going to get into all of it, but check this out. This is what was on Matthew Perry's toxicology reports. Buprenorphine, which is an opioid, okay? Buprenorphine. Notice that phene ending, like morphine, is an opioid. Lorazepam, which is a benzodiazepine, which is a depressant. There's testosterone shots. Get it, Matthew Perry, notable sex addict. Ketamine, which his blood concentration was 3540 nanograms per milliliter, which we will talk about what that is kind of like and what that means as we get into the story. Also, he was on nicotine lollipops. He also had chronic obstructive pulmonary disease, otherwise known as COPD, and emphysema and diabetes. But it was definitely the ketamine that got him, guys. No, I said, no, buprenorphine isn't a benzo. Buprenorphine is an opioid. Lorazepam is a benzo. So there we go. He's got a lot going on. Exactly. But they're blaming the ketamine. What's up, Camelot Raid, by the way? My homies from Camelot chat, welcome to the show. We are going to be talking about this. We're going to be digging into this stuff. We're going to credit Megan Fox for some excellent investigative work on this. She is, of course, livid. This is not about Matthew Perry. This is not even about ketamine. This is sacrificing the millions of people out there who utilize ketamine therapy. Ketamine is not a Schedule I drug. I believe you can actually order it online. I think I had an Instagram ad for at-home ketamine therapy the other day. Didn't even click to me till she sent me the info about this. And it's a Schedule 5, I think. Well, we'll look at it. Maybe it's Schedule 3 controlled stuff, which means in any case, whatever the classification is, there are legitimate medical uses for it. It is not Schedule 1 like marijuana and shit. The Schedule 1 list isn't as long as people think it is. LSD and stuff like that. It has these other therapeutic and medical purposes, and it is accessible to people. And right now, ketamine therapies and ketamine treatments, agree with them or not, I have never done ketamine therapy or ketamine treatments, but I know a lot of people who have. I know people who have assisted in doing those professionally. And if you want to read articles about ketamine, that is the craze predominantly on the West Coast. And when you're talking about, Silicon Valley people, tech millionaires, tech billionaires, they love this stuff. It is right now a huge drug. It's also a hallucinogen in certain doses. People are using this. They're finding help. They're getting things. None of that's going to, and of course people are abusing it. Obviously don't let me undersell it. People, abuse all kinds of drugs when they take them to the streets with the streets. When they do that, of course, there is abuse going on, but there are millions of people out there utilizing this drug in the way it's intended for its good purposes. And Johns Hopkins is going to run all over that in an attempt to build up enough public and professional sentiment to work their appeal on the Maya Kowalski decision. That's all they care about. Reducing their judgment or eliminating it entirely is the goal of Johns Hopkins. And it will create a media stir and a fracas around ketamine, and their goal is to have something like reefer madness occur with lasting legislation from retarded congressmen who know nothing about it, going against the will of doctors, going against the will of people, going against the will of voters. Fuck voters. Actually, that's kind of the whole thing with all of these people, right? Going against all of these people's desire to have a different quality of life, to have an alternative medical treatment to just being on an SSRI or something else. But you can't do that, can you? You can't get away from SSRIs. You can't do it. They want you on them because they get to charge you forever. And they hope you never get better. And if you're on SSRIs, guess what happens? Do you get better? Do you get cured? What do? Oh, you build up a tolerance on the SSRI and have to take more? And then it happens again and again. Do you ever feel better? No, just for a little bit. Then you go back to worse, or you go to feeling nothing. And you'll feel nothing and you'll like it. And you'll go from 1 pill a day to 2 to 4 to 6, and then it'll just want to feel something. So you take 8 or whatever, and then you die. Or you do, oh, there's a church, right? They don't have SSRIs. None of them are on those. That's where they want you. That's where they want you forever. They don't want ketamine therapies, which people have used to get rid of antidepressant drugs. Ketamine therapy is where a therapist administers a dose of ketamine to put someone into a sedative state where they're potentially open to suggestion, and not like hypnosis really, but they conduct therapy while the person disassociates from the ailments that are plaguing them in the world. They disassociate from their depression, disassociate from anxiety, get rid of the cares of their average day, and they're able to endure these therapy sessions. They're not anesthetized. They're not comatose during these things. They are receptive. They're able to accept, counsel. And it's people find help in this stuff. And it's so fucking frustrating when these alternative therapies come out, when these alternative things come out, and some motivated party comes in to fuck everybody else. Why? Well, we don't want to pay the judgment when we killed someone. Oh, MCK Stellar says, so a K-hole-like state. No, K-hole states are not the same. That's a full dissociative thing. And the people are not receptive or responsive. I guess I don't know. I don't believe they go that far in the ketamine therapies. It's not like people who are, either abusing the drug or using it as like a medical anesthetic where they need to do something that would hurt otherwise. They're not in either of those places. But yeah, we're going to talk about it as we get to Megan Fox's article. This is a thing that frustrates me so much. Guys, I'm a libertarian. I don't care what you do with your bodies. I don't care what you put into them. Don't go harming other people. Don't do that. Like, don't drive under the influence of any of this shit. But all of that aside, I have that basic principled stance of I don't get why the government regulates this shit in the first place. That's my principled stance. The non-principled stance on this particular drug is that right now, this particular drug is being used clinically by millions of people, tons of doctors, and they're getting great results from it. It's a very low risk drug. It has a low risk of addictiveness. I don't think it has physical addiction symptoms or anything like that. So it's technically non-narcotic. You've got a whole bunch of shit in favor of this stuff. And now you've got one company coming out to ruin it for all of those people who legitimately use it. And why? They got a judgment against them. That's it. They don't want to pay the money they owe. They want to blame someone else. They want to blame a drug that they did, that one guy in their organization disagreed with. They want to blame that, not their bad actions everywhere else in that case. They want to blame that one thing, and they're going to go to the media to fight that fight. They're not taking it to court because they lost. It's disgusting. I fucking hate it. All right. Let's hit these super chats and then we'll get into these topics. Oh, and there's more. I have another story that makes me want. I'm opposed to the death penalty, mostly on, again, libertarian principles, but there's a story that's out there today that makes me want it back and makes me want it back with violence. We'll talk about that later in the show. I have to be sufficiently past all these other topics because that one makes me really fucking angry. That one makes me really, really angry. Pool Girl says, I need help. Christmas is very depressing and it's really bad right now. Can I get prayers from everyone that my family heals and I get through the next week, please? Not trying to be a downer, but prayer helps and I'm desperate. Pool Girl, do not feel bad for asking for that basic support. Look, guys, I know not everybody on here is a Christian or a Jew or a Muslim or whatever. If you're not religious, that's fine. If you are, please consider sending up a couple prayers for Pool Girl and her family. Christmas isn't always bright for everybody. It's not. It really depends on family situations, where your family's at, where your family members are, people's health, people's finances, people's proximity and situations. So remember that there's a couple people out there who may not be in the spirit of the season. Toss a couple prayers their way. They'll appreciate it. And Pool Girl, I will definitely off stream pray for you and hope that everything works out and is better towards God's grace and towards your health and well-being. Titan Tech 90 says ketamine therapy is what is recommended for those who are resistant to all other psych drugs. I've done infusions and it helped me after 16 years of being in public service. I'm so mad. There you go. There you go, guys. That's exactly what I'm talking about. 16 years in public service, resistant to other drugs, not getting the treatments to work, not getting relief. Have you guys ever gone to a doctor and not gotten relief? Maybe for something minor, right? Like a cold or a flu. They're like, well, it's viral. So, well, here you go. Here's some amoxicillin that won't work, but just in case, take some of that and then go home and sleep it off. And you're like, well, fuck you. Why did I just come here and spend $100? You're like, sorry, we can't do anything. What do you even do? Now imagine that. Imagine that. But it's not a cough or a nose tickle. It's your entire mental health. And you go and you go and you go. And you talk to people and you do the things and you take the pills and nothing works. And then someone's like, hey, actually, there's a thing you can do. There's this drug. And it's a new thing, but you tried a bunch of other stuff and it kind of works in a completely different way. And you try it and it works. And now you see some company says, yeah, fuck all that. Fuck you and your health. Fuck you and your well-being. We got a judgment to avoid. Tofu Poncho says, Nick, ASL won a cyber. Okay. Age, I'm 42 now. Oh yeah. It was my birthday Saturday. I didn't make a big deal of it on Friday. Had Fudbusters on the stream. Thanks for hanging out, those who did. It was my birthday Saturday. I had an absolutely phenomenal birthday. Lady Rackets made it really special. We had a great time. We got to hang out with some friends and do some really fun stuff. I had an amazing dinner in downtown Minneapolis at Butcher and the Boar. The special that the butcher's cut that day was beef cheeks, braised beef cheeks. Oh my. It's like brisket, but richer. God, it was fucking good. Anyway, yeah, did some karaoke, had a great time, and it was just a fucking blast. But I'm now 42. 42. So that was good. Sex? Hell yeah. Sorry, that was Don't Be a Menace. I guess I'm a guy. Male? Is that there's so many of them now, I don't know. I think male is the one I qualify as. But yeah, and location, well, you know me, baby. Central Minnesota. Want a cyber? You know how many years? You know how many years I've been waiting to be proposed to in such a romantic way? I will stick my keys in your cooter, bitch. Yeah. Thank you very much. Thank you very much. 42 male, Central Minnesota. Type at me, baby. Sean says he should never been prescribed buprenorphine with benzos. It's known to cause death from depressed heart rate and breathing. Yeah, that's kind of part of it, isn't it? It's a big problem. Maybe one of those wasn't prescribed, right? This is Matthew Perry. This dude's an addict. Maybe that buprenorphine or whatever it is, buprenorphine, lorazepam was not, maybe that was not planned or known by doctors. Eternal Hex's birthday is about to end. Hey, happy birthday, Eternal Hex. How you doing, man? So there you go. Yeah, we will. And again, we'll talk about that shit when we get into Megan Fox's article on the subject. Again, I'm going to tip Megan Fox on all that work. We're going to lean heavy into her article. I encourage you guys to read it, support her. She's medium smart, but when she is tenacious as fuck, and when she gets on a subject, she will track it down with integrity, with courage, with honesty, and she'll rip it apart, and she will go straight to the throat of the people who deserve it. That's why we love her. She's fucking fearless. And she is, I said, well, tenacious. I'm not going to re-say tenacious. She's cool though. She's cool. But yeah, Frozen Toy says, hey, Nick, can I get a birthday toast? I turned 52 today. Oh, yeah, you can. Yes, you can. Sorry to yell into the mic. Yes, you can. And with that, my friends who are helping celebrate my birthday gave me this brand new whiskey from my favorite company, Kentucky Owl. This is one of their crossover bourbons. We've had a little bit of it, not much. We just had a little taste each because we were hanging out for the night. Like, we were out for the night, so we didn't want to drink too much of this, but it's really good. It's a collaboration by Maureen Robinson, who's a Scotch whiskey master blender. I don't know where from. And John Rea, who's the Kentucky Owl master blender. And these collab bottles are fucking fantastic. All of them that I've had are really good. This is the Meister edition. Meister, whatever. We're gonna have a little bit of it. It's really good. I'm not gonna do a review on it or anything. We're just gonna do the toast. But I just want to give a big thank you because I love this bottle. It's really fucking great. And yes, I'll lick it. I'll lick it twice. All right, here we go. To Frozen Toy, cheers to you. Happy birthday, 52 years, ripe and ready. May you have 52 more and then some, and let that collective experience of those 52 years never make you feel aged, but just make you feel experienced. Enjoy life and take it the next year wherever you will. Cheers. Delicious. Randy V says, what do you think of your new flag? It's shit. It's shit. Everybody who says, look, there's a bunch of people out there complaining. They're like, oh, it looks like the Somali flag. Little Somalia. They got these retarded comments about like Somalia influence on the flag design. It's looking like they're right. They're 100% right. Looks like the Somali flag. It's this weird cuckening. Like, I mean, I have actually apologized for, the Somali refugees in a lot of cases. Not all of them are awful, and there's good reasons that Minnesota has been a landing place for them. And a lot of the Somali communities are not garbage. And so I'm resistant to people who generalize the really shitty ones with the ones that are pretty much decent. They may have some cultural differences, but I don't see a bunch of Sharia like out where I live. Certainly there's bad apples and bad actors. Of course. Make no mistake. But that being said, like, I don't like lumping anybody into a group. That's one thing. But changing the state identity to be a mirror image of the Somali flag is fucking weird. Fucking weird. That is something that makes no sense to me. The flag's ugly too. It's just ugly. I fucking hate it. But hey, I mean, I'm not a flag designer. Neither is that guy, I don't think. But It's a mess. It's a fucking mess. But hey, that's where Minnesota is. That's where it's at. That's how Minnesota's going. Here we go. Let's but yeah, that's what I think about it. Maybe we'll talk more about it. But for now, that's where we're gonna be. Let's get to this Trump spot. Yeah. We will get to Donald Trump. We will find him. We will make him pay. Let me get this pulled out here. Blah, 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 blah. This is from the Associated Press. Fucking hell. Guys, I'm in a really good mood tonight, so you'll have to forgive me for being a fucking moron, but I'm just happy. Do this story in Trump's voice. The judge criticizes Trump's expert witnesses as he again, multiple times now, too many times, disturbing number of times. I've been to a lot of trials, lots of judges, this one particularly not good, as he again refuses to toss the fraud lawsuit. Well, Judge Engoron, in fairness, cannot toss a lawsuit when he is so busy tossing salads. Because licking buttholes. All right, here we go. Here we go. Sly goes, when are you going in the kill stream, Nick? I haven't scheduled it with Ralph. Decembers are really like a fucking mess, and scheduling things is not something I am able to easily do because I don't always know when I'm going to be home. We'll probably get around to it in January, and stuff like that. But yeah, I'm Ralph and I have buried the hatchet. There's still some weird vibes about past shit, and I try and let all that go. We'll let time deal with most of that, but I do plan on being on the kill stream on Monday. I'm glad to see Ralph seems to be doing much better, and I'm happy to catch up with him. So, or not Monday, January. January is the Monday of the fucking year. On January, hopefully we'll get that show scheduled sometime soon, because I do want to catch up with him. I do want to, like, to his face say that I'm really happy to see that he seems to be in better health and better spirits. What I told him a long time ago when his family shit started really going south this recent time, I sent him a message, and I hadn't talked to him in a long time, but I sent him a message and I just said, hey, Ralph, look, I know we have bullshit between us, but internet shit is internet shit. You're dealing with real life stuff. And the one thing that always hits home with me is families and family strife. And I said, so from my end, man, the hatchet's buried. Your real life shit is way more important. And what I want is everybody involved, no matter what the resolution is. Cause I don't know. You never know people's situations, right? Like, whatever the resolution is, I want everybody involved to be safe. I want the kid to be safe. I want you to be safe. I want May to be safe. That's what is way more important than any shitty slap fight we've had. And I let that be. Ralph responded very kindly to that, and said we can, the beef is so unimportant that shit can go to rest, and we'll let the rest of that work out. But yeah, I'll be on the kill stream as soon as we can get it scheduled, probably in January, because I'd like to catch up with him on that. But William Dixon, oh shit, Woodman Gaming, new flag ugly, old flag was boring, seal on flat background. Oh, the old flag was boring, but it's so. I just got a new house, no land for gun range though. Shit, sorry, man. But yeah, the old flag is boring, but lots of flags are boring. Who cares? It was the old flag, and the reasons for getting rid of it are stupid. William Dixon says, prayer for you and your family. Hey, thank you, William Dixon. Right now, my family and I are doing great. We really appreciate that. Though that sentiment, it always is warm to see people send good wishes. Former President Donald Trump has lost his latest bid to end the business fraud lawsuit he faces in New York as he campaigns to reclaim the White House. Judge Arthur Engoron issued a written ruling Monday denying the Republicans' latest request for a verdict in his favor in a lawsuit brought by New York Attorney General Letitia James. Let me see how long this ruling is. We're probably not going to go through it on this show. I think the article will suffice for what I want to say. Oh, it's only 3 pages? Fuck, let's just go through it. Fuck the article. Hold on, let me get rid of this stuff. Go away. All right. This will be good enough. This is only 3 pages long. This will be actually a much better solution than fuck the AP. All right. MKC, good night. You should always be nictarded. Good night. Make sure you catch the rest of the show on replay on YouTube or on Rumble. And if you guys like the show, if you like the vibes, the energy, the topics, whatever, if you like the bottle licking, if you like the me being an asshole, click the like button. I don't ask enough, and it's weird because I hate asking for people to do that, but it is a fantastic reminder to the platforms that people are watching and engaged in the show. I really appreciate it when you guys do that. It helps me out tremendously. I haven't asked for it a lot, but that little reminder does tend to get people to do it, as weird as that is. So please and thank you on that one. All right, here is the Judge Engoron decision and order denying defendant's motion for a directed verdict. At least 5 times during the recently concluded 10.5-week trial of this matter, defendants have moved for a directed verdict. Hey, Judge Engoron, let's be very clear. The number of times that they have moved for the directed verdict is irrelevant to the merit of each motion for directed verdict. You prissy little fucking bitch. It doesn't matter if it was 5 times or 1,000. In fact, it should have only been 1 because this trial is bullshit. When you actually get the evidence out there, which they now have, it's bullshit. And it's clear it's always been bullshit. So fuck you and your 5 times. Fuck you. I fucking hate judges, especially this one. The first time was at the close of plaintiff's case, which is when defendants normally move for such relief. Cool. Great. This court took that motion and most of the others under advisement. It denied 2 of them on the spot. At the close of plaintiff's rebuttal case, defendants requested permission to move yet again, pursuant to CPLR 4401 for a directed verdict. Plaintiff opposed the request, not wanting to impose an undue prior restraint. This court granted the request. Oh, how benevolent of you to grant the request for another directed verdict after the court or the plaintiff still had not made their case according to the defendants. The instant letter motion ensued. This court hereby denies that motion and furthermore denies all the prior motions that the court previously took under advisement. Notice they've made 5 motions. He has not ruled on all of them. There's still some that he had not ruled on. One such motion came immediately after the close of the testimony of Michael Cohen, whom defendants wishfully denominated plaintiff's star witness. In denying that motion, this court noted that the evidence of wrongdoing already admitted into evidence was voluminous. Actually, it's kind of funny because the evidence of wrongdoing already admitted into the case was irrelevant to the outcome of the case because the judge made his ruling prior to the trial. Made it on a summary judgment. Improperly. Very improperly. WILK1214 says, you're a Sharia supporter? What the fuck? No. No. Jesus Christ. How do you hear but never listen? Okay, here we go. Rather than marshal in detail, yet again, the evidence in support of plaintiff's prima facie case and defendant's failure to do more than raise issues of fact, this court will highlight some of the fatal flaws in the instant motion. Okay, here's the reason. This is why this judge is amazing. Because the judge granted summary judgment in ruling prior to trial that Trump was guilty of fraud. And then the trial was about the level of fraud, the amount of damages that Trump should have to pay. So the judge had predetermined the guilt. So when he talks about raising issues of fact, the reason they're raising issues of fact is the summary judgment standard is there must be no genuine issue of material fact in dispute. So they're raising these issues of fact because you gave a judgment to the plaintiffs where there were material issues of fact in dispute and you violated the summary judgment standard. They're showing you over and over how you violated the summary judgment standard while asking for a directed verdict. You fucked up, and they're telling you about it. And the court's like, nah, we're just going to highlight the fatal flaws of the instant motion. Let's do that, Engoron. Thank you. Thank you. Outpost Nerd says things that are old like Nick, Biden, the Roman Empire, the wheel, fire, and dirt. Happy birthday, you Shasta lawyer. May your super chats be many and your whiskey glasses never be empty. Thank you, Outpost Nerd. I appreciate that. Also, K to the Swiss, thank you very much for the support. Love it. Always encouraging. Always wonderful. We do have a couple over on Rumble here. Night of Hope says, let's be real, there's going to be a bunch of dumb fuck voters who like being angry at drugs for moral purity reasons who will go along with this completely. Hey, look, some of those flags are in the chat. Fahags, he said, not flags. Yeah, well, it's not even that they're dumb. They just they'll just listen to the media story and go, oh yeah, that's a street drug. It's bad. It's not a street drug. It's a proper drug that people use on the street, like many, many other drugs. K Campbell, 48 says, Nick, UPS lost a check that was supposed to have been here on the 13th. Can I sue them? Probably not. Probably not. All right, here we go. Here we go. The most glaring flaw is to assume that, listen to this criticism from the judge who's supposed to be the finder of fact in this case. The judge here is supposed to find the facts. He's supposed to listen to evidence, take it in, and make determinations on the evidence. But listen to this. The most glaring flaw is to assume that the testimony of defendants' experts, notably Misters Jason Flemons and Eli Bartov, is true and accurate, or at least that the court, as the trier of fact, will accept it as true and accurate. Why wouldn't the court accept it as true and accurate? Oh, you're about to find out. This is evidence that I'm black, by the way. Bartov is a tenured professor. He's the expert. But all that his testimony proves is that for $1 million or so, some experts will say whatever you want them to say. Wait. So he is saying, the judge in the case is saying that this expert charged money, therefore his testimony is not true. Now, every expert in every case basically is charged some amount. And you can always attack their credibility based on what they're getting paid, but all of them are getting paid. All of the experts are getting paid. Why do you assume that these experts, who are well paid for sure, why do we assume that they're compromised by their paycheck and no other experts are? He's saying that these experts lied under oath. I mean, effectively, right? His overarching point was that the subject statements of financial condition were accurate in every respect. Okay. As this court discussed in excruciating detail in its September 26, 2023 summary judgment decision, the statements of financial condition contain numerous obvious errors, but those are in dispute. There's a guy saying they're in dispute. By doggedly attempting to justify every misstatement, Professor Bartov lost all credibility. Dr. Bartov suffered essentially the same fate testifying before the Honorable Barry Ostreiger in People versus ExxonMobil in 2019. The court rejects Dr. Bartov's expert testimony as unpersuasive, and in the case of his testimony about the Mobile Bay facility, finds Dr. Bartov's testimony to be flatly contradicted by the weight of the evidence. Wait, so in another case, you're using a court in a different case's rejection to bolster your argument of rejecting him in this one? That's not how this works. That's not how evidence works. That's not how experts work. That's not how any of this fucking works. But hey, who cares, right? Do you understand how crazy this is? So the judge, remember, the judge issues his summary judgment ruling by stating that the court finds that there are no material facts in dispute. None. That's the only way you can issue summary judgment. That's the rule. That's the legal standard. Has been forever. When someone comes out and offers a dispute about those facts, the judge now must say that he must be lying because we determined that there were errors. So if he says there aren't errors, there must be errors because we determined there were, even though he says there aren't. But that's a fact in dispute. He's supposed to find that as the trier of fact. He shouldn't have ruled summary judgment. He should have had to listen to this guy's testimony, but he didn't. This is his problem. It's fucking unreal. But hey, Mr. Flemons acknowledged that he had never valued property, much less was he a valuation expert, but he attempted to opine on values. The crux of Mr. Flemons' testimony was that so long as defendants selected one of the methods that ASC 274 permits, then any numbers may be entered into such methodology regardless of their accuracy or relationship to reality. Wait, there are rules. Again, the judge is stating that there's a set of rules you can follow for valuations. And this guy says, well, if you use the rules, how can it be a lie? If you follow the methods that are in this rule, how can it be a lie? And the judge just says, because it can. Well, he's never done valuations. Well, I mean, is he an accountant? Like, what do you want out of him? The judge, by the way, could have limited the expert's testimony. He could have done that. Why didn't he? No, you can't talk about values. Great. But did you do that? So here we go. Mr. Flemons also inexplicably acknowledged that future income had to be discounted to present value on a financial statement, while at the same time stating there were no generally accepted accounting principles, departures where defendants failed to apply a discount rate to future income. He opined that Mazars should have followed up on items in the SFCs, but then stated adamantly that it would have been highly unusual for Mazars to make an inquiry for any appraisals in the client's possession. Okay. Number 3, in any event, there's documentary evidence previously submitted to the court on the parties' summary judgment motions, conclusively establishing that Mazars did in fact make inquiries for appraisals and were told there were none. Okay. He was reluctant to acknowledge that an asset controlled by a third party cannot be considered cash, while also acknowledging that it was a red flag. All right. Again, if you want to have criticisms about this thing, that's fine. But I do have to point out that this isn't really the place for that, because you've accepted that testimony. You don't have to explain why you're not going to consider it in your ultimate ruling. This is a motion for directed verdict. You have to just say that you have to go through the standard for the directed verdict. Here he's going after individual experts, and he's essentially saying that the experts are lying or misrepresenting things. Yet, of course, someone asked, well, did you charge him with perjury? No, he won't do that. They'll never do that. But hey, he's just going to treat them as if they're perjurers. He's going to disregard their testimony. And the fact that they have testimony that contradicts the fact that there are no material facts in dispute, he's got to get around that. That's what he has to go after. And of course, he's just flat out lying, saying there's no material facts in dispute, because he's telling us that there are. Andrew Hicks says, work all day driving all night, MA, and then work 17 hours for storm duty. Might not be home for Christmas. Damn. Give thanks for utility worker. Also part of the 4K channel squad, 4K Chad squad. Thanks, Maddox. Dude, how you been, Andrew Hicks? It's been a minute. I haven't seen your name in a while, man, but I remember you from the fucking Maddox days. Such good times. Such good times. We'll give a cheers out to those utility workers, those people who do, the long hours over Christmas to make sure everybody's fucking lights work. Cheers to you, brother. May your busy Christmas merit you and net you some much needed time for yourself, for your family, for your friends, for your relaxation, your leisure. May the bonus check and the overtime be worth it. Cheers to you, brother. All right, here we go. Defendants persist in arguing that if a loan closes prior to the period during which the statute of limitation allows suit, then any required follow-up SFCs made during that period is somehow sacrosanct. That contention is belied by a plain reading of Executive Law, Section 63:12, by the law of the case doctrine, and perhaps most importantly, by common sense. Closing is not a get-out-of-jail-free card for future misstatements. All that Section 63:12 requires is a false statement used in business. Subject of financial statements fit that description, or the subject financial statements fit that description to a T. So, again, they're basically saying everyone was paid. They're paid. He's saying, well, if any follow-up SFC, subject financial, or SFC, I think that's subject financial something, made during that period somehow sacrosanct. Well, I mean, it's paid. It's done. I don't know. Not sure exactly what he's coming after here. In their zeal to protect the record, which is important for the appeal, of course, defendants yet again raise a specter that plaintiff has no standing and no capacity to bring the instant action. This court has confidence that the Court of Appeals can easily reach and determine those arguments which personify frivolity. So they still have to protect the record to make the appeal. I'm glad you are glad that they can do that. And you may be right. Like, it seems like they have standing to bring it, of course, because the statute says that they do. My question is more of a constitutional question, which we're going to get into in a minute when I start really screaming about this. Renee Villarreal says, the Pope is gay. May all have great Christmas. Going to enjoy entering my 30s tomorrow. Oh, shit. Happy birthday tomorrow. Don't call it Dirty 30. Please just don't call it Dirty 30. Don't do that. Just be 30. Just do that, though. Cheers to you. Happy birthday. Here we go. Defendants' arguments against disgorgement fall short in three respects. Disgorgement does not depend on damages, a different concept. The testimony showed that the lenders did rely in part on Donald J. Trump's SFCs, but did they rely materially on his SFCs? And importantly, did they rely on the misrepresentation in the SFCs? Did they rely on that? Because if they just rely on the SFCs in part, sure. Statement of financial condition, that's what they're called. God damn it. Sure, of course they relied on them in some way, but they also have their own processes. And Deutsche Bank, the Deutsche Bank witnesses blew all this away. They said, well, yeah, we came to a different conclusion on his income or on his personal financial statements by a lot. He said his net worth was this. We concluded it was this. There's a huge gap there. And they said, but you know what? He met all of our thresholds. Everything was fine. We had our own due diligence done. We had a duty to investigate his thing. We determined that, he came to his conclusion. We came to ours, and we wanted to do business with him at the rate that we did. And of course, they all did this. It's not a fucking mystery that this is how banks work with high net worth individuals. They have to work this way. And remember, your personal net worth is a guess. It's an opinion. And you pay people to make that opinion more and more accurate. But your net worth, anyone who owns a house right now, your net worth includes the value of your house. Well, your equity in it. What's your equity position today in your house? What is it? How do you know? You didn't sell it. You don't know what it's worth. You talk to a realtor, they're going to say, oh, I can sell that for $200,000. You talk to your tax guy, it's like, well, it's worth $98,000. You actually sell it. You sell it for $156,000. That's the only price you can actually represent as the net worth because you just sold it. If you talk to an appraiser, you get maybe a more accurate value. All of these people have different opinions of it. Now, that's just a house. Imagine it's a fucking building, a skyscraper in New York. How much is that worth? How do you tell? How do you value that? Does a skyscraper have special meaning? Is it Trump Tower? Do you have a name attached that makes it more important? How do you value these things? You make a good guess, but if you haven't sold it, you don't know. The market could fluctuate upwards, downwards. Your name stock could be worth something more tomorrow. This is what they're really stuck with. And the fact that the judge is just going to ignore that and say, well, he lied there, but did he lie though? Did he actually lie? He says they're misstatements, but having a different opinion than the New York Attorney General is not a lie automatically. I mean, those things could coexist. Renee Villarreal says 30s aren't dirty, just another stage of life. A dirty 30 makes you as gay as the Pope. Cheers. Damn. I assume you mean, well, if you're talking about me, obviously, but the real Pope, Francis, his name's Francis. Of course he's gay. All right, here we go. So they did rely in part on his statement of financial conditions. In section 6312 contemplates disgorgement. Disgorgement is the return of ill-gotten gains. If you pay a lower interest rate on a loan by overstating the value of any of your assets, thus lowering the perceived risk to the lender, your gains are ill-gotten. But only, now actually that's not true. That is not true. This is the frustrating part of this. It can be true, but it's not automatically true. As Deutsche Bank demonstrated, his misrepresentations or his disagreement on net worth didn't actually net him a lower interest rate. Just because you claim a higher financial position than you have does not automatically get you a lower interest rate. That depends on the bank. Plus, the bank's due diligence may turn up their own numbers internally that would justify their rate anyway. And at the end of the day, this is a contract. And while there may be a quote unquote misrepresentation, misrepresentations in a contract are not always unlawful. The misrepresentations have to be knowing and intended to gain a benefit or to cause harm to the other person. Those misrepresentations, and they have to be present at the time of agreement with those things in your mind. That is not an ill-gotten gain if you didn't intend those things. But because, and here's what I mean. If Trump just misstates his net worth because he overestimates his property value, but he doesn't intend anything negative by it, he just says, no, I think this tower's worth more. I think it's worth this. And he values it that way. Okay. And someone disagrees, you could say it's a misstatement, but you can't automatically say it's a fraud. And this is where the problem is. The gains have to be actually ill-gotten. But the gains first have to exist, and then second have to be ill-gotten. I don't think they are in this case. The lender has lost money. No, it has not. Although the loss is not out of pocket. And so the loss is not what the law traditionally thinks of as damages. Oh, it's not what the law traditionally thinks of as damages? So how can you say they have lost money? What he's saying is that the lender has lost some unspoken right to a future income that would have occurred had a higher interest rate been applied. But there is a missing factor to this equation that Judge Engoron is completely overlooking. And I don't know if Trump's attorneys hit on this. I don't know if Trump hit on this. But this is the main question I would have asked Donald Trump if he had taken the stand, which he did not. However, some of his other advisors may have been able to answer this question in their testimony. But the question is simply this. Mr. Trump, had Deutsche Bank offered you a rate of 3% instead of 2.28%, would you have accepted the loan? And the answer is no. I would have negotiated for a lower rate because I'm Donald Trump, very good at negotiations, very good at business. I've done this a very long time. And if we're not going to get the best rate, we're going to do business somewhere else because they want my money. They want to lend me money. They want to make money back. They know I'll pay it. There you go. Done. The judge is ignoring the other side of the contract in this. Failure to obtain a higher interest rate by the bank automatically presumes acceptance by the defendant, but the defendant may not have taken the loan, and there's no way to state that the defendant definitely would have taken the loan at a higher interest rate, especially when the defendant has leverage. And in this case, both the defendant and the bank have 100% leverage on the contract. It's a weird situation. The bank has the unequivocal ability to ignore any piece of business it wants. It's a massive institution. It is not dependent on any single transaction. Donald Trump is exceedingly wealthy with a massive network of professionals, advisors, and connections, and he has any number of lenders and investors to go to on this who could give him a competingly lower interest rate if he so chooses. Sure, it's work for him, but trust me, 2.28% versus 3% on a $50 million loan is a fuckload of money. So why do we have to assume Donald Trump would have taken a higher interest rate loan? We can't assume that because it didn't happen. We can only know that Donald Trump and this bank had a meeting of the minds on the information given at the interest rate. And to suggest that the bank is entitled to more money is to flatly fucking lie. It's to lie. Now, there is a scenario where lying to the bank can actually get you a loan in a weird way that will do this. There are very small dollar amount loans that banks give to a lot of people. And the reality is acquiring those loans is a math formula. Credit score, payment history, money in the bank, income, whatever. And if you lie about one of those things, if you're able to misrepresent to the bank one of those things and get them to accept it, and there's not some real process around it, it's literally just plugging numbers in. Here's your credit card, Mr. Smith, or whatever it is. Maybe you can actually, avail yourself of an advantageous thing by misrepresenting there. And there's not really any diligence done or anything like that. The bank just has this open policy. If you meet this condition, this condition, this condition with these documents, you forge the documents. They have no reason to do anything other than take your word for it. And they grant you the thing that they promised to give you. Well, now you've lied to induce the production of something that you knew would be produced. But these transactions are so fucking much more important than that. Adam 1083 says Trump did take the stand twice. Once because Judge Fag called him to it. The other to testify. Trump actually did not testify. He did not take the stand in his own defense in this trial. I know he testified because of the gag orders, but I don't think he testified on the facts of this trial. He said he was going to, but he changed his mind last minute. But either way, that's the question. That's the ultimate crux. Would you have taken the fucking loan at the interest rate that they say you should have been charged? They just say, no, I would have walked down to the next bank on the street. There's one 2 feet away. Guys, when I was in West Palm Beach to go to Mar-a-Lago, the only thing there is all financial institutions and then like fucking McLaren dealerships. That's it. That's it. And it's all financial institutions. You're telling me Trump couldn't just walk somewhere else and get a loan? Of course, he'd do it in New York. So he just walk down to the next bank in Manhattan and he can walk in and negotiate for a loan. But here's the thing. Those banks aren't going to kick Trump out the door. They would never do that. They will bend over backwards. They will definitely give Donald Trump the lowest rate. And they don't really care if he misrepresented it. They don't give a shit. Because they still knew it. All right. Here we go. But see, this is why it's not what the law traditionally thinks of damages. Well, then it's not damages. That the instant lenders made millions of dollars and were happy with the transactions does not mean that they were not damaged by lending at lower interest rates than they otherwise would have. Mikhail McCartney's testimony credibly supported this. Listen to that fucking statement. That the instant lenders, which means all of them, all of the lenders, made millions of dollars and were happy with the transactions does not mean they were not damaged by lending at lower interest rates than they otherwise would have. What a fucking statement that is. What a massive, massive fucking statement that is. You have to wonder how that can possibly stand. How can this law be just? The people who are the victims have no complaint are happy and made millions. And yet here we are. Trump stands to lose $250 million in all of his business dealings in New York. In a civil trial, not a criminal trial. He doesn't get a jury. Not that a jury would be particularly helpful for him, but actually, look at this judge. Yes, he would. Yes, they would, because a jury would have to listen to those experts, and the jury would not be able to cite another case in which the expert was found to be not credible. They would need to cite, they wouldn't be able to cite another case and just determine that this jury, that the Trump's expert was lying. They'd have to listen to Trump's experts and go, oh, yeah, I actually, you know what? I get it. They'd have to do that. But this judge doesn't. This judge gets to just determine that the experts are lying based on his own personal opinions about their testimony and their compromised nature. It's unreal. Speaking of unreal, we are going to pop over to Rumble exclusively. There are 2,000 people watching here on YouTube. There's almost 4,000 people watching over on Rumble. I do hope you people on YouTube do want to pop over there. You can click the link in the pinned chat or in the description. I'm going to read a couple more super chats on YouTube. Thank you to everyone who sent in super chat and contributed to the show today. We are going to continue on Rumble right after we get done with those, and then we'll go on with this Trump thing, and then we'll move into the Matthew Perry story. Kyle Villain says, fat shame me so I can feel as skinny and as tall as you. I haven't had pop in over a year, but it hasn't helped. Make me stop eating to lose 30 pounds. Kyle, this is very important to you. And it's very important to me as someone who is utterly disgusted by your look, your shape, and your smell, particularly the last one, because you smell fat to me. I'm going to need you to try something. And it's going to be hard for you, as obvious evidence is showing. You're going to have to not eat. No, I did not say eat less. I said you're going to have to not eat. Just stop. Oh, but I'm hungry. You're not hungry. That's a routine you're doing. You're doing a routine of shoving a box of Cheerios into your mouth while shoving a box of Lucky Charms up your ass to get more calories in, but at least it'll be sweeter on your butthole. You need to stop putting food into you and start getting fat out of you. And it starts with you not eating. You got to break that habit. Get out of it. You've been conditioned. Oh, the food people. I got to eat 11 slices of bread a day. Dude, you don't need to eat any slice of bread or anything else. Eat a slice of air with a side of nitrogen. Go to sleep. Every time you're hungry, go to sleep. Lay down. Lay the fuck down. I know you're comfortable laying down. And you don't even have to like fall. You just roll onto the side like a boulder. Like when the angels moved the boulder in front of Jesus's tomb, that was just you. You're like, hey guys. And they're like, that's keeping you from a hamburger. They were trying to save you. Stop it. Stop eating. You're fucking fat. Bitch. There you go. Lose 30 pounds. Make it your goal to lose 100 pounds. Because you're so good at failing, maybe you'll fail into success. Happy birthday, whenever it is. Some guy with cancer says, every time this judge speaks, we stray further from God's light. I'm a tax accountant, and this clown couldn't pass accounting 101. Nailed it. Nailed it. Not sure says, say a prayer for high-speed ballistics. Had an RPG accident while filming. You should review the video live. Merry Christmas, my friend. Hope 24 is better than 23. I'm not 24. Oh, you mean the year. Yet 23 is a really weird year. It's been the biggest peaks and the shittiest valleys. But yeah. Okay, so high-speed bully hit an RPG accident while filming. Holy fuck. Is he dead? Or just hurt? Review the video live. Well, I won't do it on YouTube. We got one. I think that's what we got. Yep. Very good. Very good, guys. Thank you over on YouTube for all of the support. Remember to click like on your way out. Pop on over to Rumble. We'll see you over there in 25 seconds. And then we will continue with this story. And again, get to Matthew Perry and the dose of ketamine that miraculously kills an addict when it wouldn't kill anybody else. Catch you in a moment. Peace. Peace.